Okay, hello, good morning, everyone. We're just coming up to 10:02. I think 2 minutes is enough to allow everyone to join. So good morning, hello, and welcome. This is our September edition, although it's the last day of September, but our September edition of Hot Topics. So this month we are focusing on an extremely current and relevant topic, and that is the prevention of sexual harassment. So prevention of sexual harassment in the workplace, prevention of sexual harassment outside of the workplace, and of course, prevention of sexual harassment or indeed sexual assault in resorts. So perhaps for your customers as well on holidays. So matters affecting not only your employees, but customers as well. So we're going to have various presentations today, really addressing this issue from all angles. And there will be time for questions as well. So please do feel free to chat away in the chat. If you have any specific questions, pop them in the Q&A tab, and we'll pick those up as we go along. I do appreciate this is a sensitive topic, so if you want to remain anonymous, that's absolutely fine. You can just message me or one of the other speakers directly, or alternatively, if it's a really fact-sensitive matter, feel free to pick up with us directly after, and we can discuss that with you. We are recording, and this will be shared with people who perhaps can't attend the live session later. So like I say, if your name comes up or anything like that, it will be shared. So just be aware of that. So why are we doing this session today? Well, there's a couple of reasons, really. The main one being recent changes. I say recent, they've actually been about for a while, but maybe not known to everyone. Recent changes in legislation. Legislation that now imposes mandatory requirements to businesses to prevent sexual harassment in the workplace. And Amy will be chatting about that in a lot more detail in just a moment. Also from a general perspective, and from what I've been seeing from a litigation point of view, is that the number of complaints and cases and then claims involving allegations of sexual harassment and indeed then sexual assault has increased, that I've seen significantly over recent months, and most definitely a noticeable difference in the past year. There's potentially a number of reasons as to why that is, and we'll talk about that during today's session. But because of this increase and the awareness around this subject, it's absolutely vital for businesses to be aware of the issue, to spot risks, and to seek to mitigate those risks as far as possible. And then, of course, if you do receive a complaint or a claim, you know what steps to take and how to deal with it. So just on our next slide here, a bit of an agenda as to what we're going to be looking at today. Prevention of sexual harassment in the workplace, and some recent, relevant and mandatory, that's the key word, legislation on that point. So this covers, as Amy will explain, not only when your employees are in the office, so sexual harassment maybe from fellow colleagues, but this also now extends to third parties and events that take place outside or away from your normal place of business. So conferences, awards ceremonies, staff in resort. So really, really important for our industry. We'll look at how these instances can impact your wider business model, how instances involving those maybe not immediately within your own sphere of control can still have an effect on you, your customers and your staff. Very importantly then, what steps you as a business can take, indeed what steps you must take to ensure that you comply with these legislative requirements. And finally then we'll look at some real life scenarios that we've come across over recent weeks and months to discuss how these can be addressed. So really today is all about looking at areas of risk to your business and what you can do to mitigate, minimise and respond to that risk. So to set us off, I'm going to pass over to Amy, who's our employment law expert. You all know Amy by now, to set the scene and really lay the foundation of what we're talking about today. So over to you, Amy.
Thank you. Good morning, everyone. And nice to see some familiar faces and some new ones. There is a poll, so if you haven't already responded to that, could you just take 2 seconds if you'd like to answer that? Because at the moment, we've asked the question, has your business taken steps to mitigate the risk of sexual harassment in the workplace? And we're currently about 67% of businesses who have said yes. The remainder either haven't or they don't know if their businesses have. So that's quite a useful indication as we sort of navigate our way through this morning's session. I am primarily going to focus on the workplace because there's been a lot of movement in this area over the recent year, and there will be more changes ahead next year. So the prevention of sexual harassment is not a new concept. That's the first thing to remember. We've had sex discrimination legislation in force since 1974. That was incorporated into the Equality Act of 2010, which is still binding and still the main piece of legislation in this relation to this area. And that's always prevented 3 types of harassment. Firstly, harassment related to protected characteristic, whether that's age, religion, sex, maternity, the 9 protected characteristics. There's a special category of sexual harassment, which is the one that we're really going to focus on today. And then there's a 3rd category of harassment, which is less favourable treatment because the employee rejects or submits to unwanted conduct of a sexual nature or that is related to gender reassignment, and then they are effectively victimised, so they don't get a pay rise or they don't get promoted. So this has always been in force, certainly since 2010 when the Equality Act came through. However, last year on the 26th of October 2024, there was an amendment to the Equality Act, which I'm hoping that some of you at least will be aware of, which was the Worker Protection Amendment of Equality Act 2010, Act 23. So why did that legislation need to be put in place? For a number of reasons. I think Christine's already alluded that we are seeing a lot more of complaints, not only from employees, but also from customers. Now, I don't personally think that the number of complaints or incidences has gone up. I just think people feel more comfortable now in raising these issues. There's been quite a few media campaigns, #MeToo. The invention of social media means that the news can spread very quickly. And also society's changed. You know, I always use that example of when I was a trainee going to a construction office headquarters and the MD had a page 3 calendar on display in the background. That sort of behaviour is no longer tolerated by society. Even if we think of the tabloid newspapers, you know, until 2010, there was a page 3 feature every day. Again, that's something that society has shifted away from. So society has changed. The invention of social media means news spreads quickly, and I think people are basically more prepared to speak up to stamp out this type of behaviour. So with that all sort of coming together, the government, and it wasn't the Labour government, this was already in place by the last government, decided to introduce this legislation. I think it's fair to say as well that this is probably one area where it doesn't matter which side of the House of Commons or the House of Lords you sit on, there is a united aim here to stamp out sexual harassment in the workplace. So what this amendment to legislation did was create a new statutory duty. It's a preventative duty and it's a mandatory duty to prevent sexual harassment in the workplace by taking reasonable steps. Reasonable steps is not defined. Reasonable is that word that lawyers always hate, because what does it mean? Well, it will depend on the size of your organisation, your resources. So what the tribunal would expect a very large employer to do will be very different from an employer, say, with 2 employees who won't work remotely and so on and so forth. If a business fails to take reasonable steps, then not only can an employment tribunal uplift damages by up to 25%, and it's worth noting that damages, compensation, call it what you want, for discrimination and harassment is unlimited. You will have heard some headlines, you know, of many hundreds of thousands of pounds. Those are the extreme cases. But what I can tell you for sure is that, you know, if there is a finding of sexual harassment, it's highly unlikely that a tribunal is going to award a very de minimis amount because it undermines the severity of the sexual harassment in the first place. In addition to that, the Equality and Human Rights Commission can make recommendations and intervene with the employer to suggest improvements. But aside from the legal obligations, I think employers really need to think about their moral obligations to their employees about creating a safe working environment, and the health and safety at work legislation applies to all employers. But in addition to that as well, there is a reputational risk. These things attract press publicity. You know, you and I would rather read about something juicy in the newspapers than an unlawful deduction of wages type claim. Not only do they attract adverse publicity, they could also act as a barrier in terms of your retention of staff, who, if they don't see that employees are dealing with it very well, will want to maybe move up sticks and move to another employer. But it could also act as a barrier to you recruiting staff, because word may have got out and employees may think, well, that's not the sort of employer that I want to go and work for. So that said, let's just focus on the requirement to make reasonable adjustments. So it's a preventative duty, it's an anticipatory duty, and it's designed to transform the workplace by creating cultures and requiring employers to take positive and proactive reasonable steps to prevent sexual harassment of their workforce. So it will be no defence if you've taken no steps. But what do we mean by the types? What do we mean by the types? So I'm not sure which slides you've got on this. There seems to be two slides moving around in the background, but hopefully you've got a reasonable step slide in front of you. As I've said, it will vary from employer to employer. The law doesn't list specifics of what employers must do, but there are certain things that you as an employer need to think about. A policy, I think, is a basic these days, but there's no point having a policy that's shoved in a drawer that no one ever looks at again. In addition to a policy, there needs to be training. There needs to be training to your staff on what is and is not acceptable in the workplace. And there also needs to be training to managers on how to deal with such issues as and when they are raised, but also what their obligations are in terms of a bystander. Because if a manager witnesses something and doesn't do anything about it, or even if an employee witnesses something and doesn't do anything about it, then how are you going to be able to demonstrate that you're taking reasonable steps to prevent this from occurring in the first place? In addition to that, audits, risk assessments are very useful tools to do, especially if you have occurrences such as overseas or overnight travel, lone working, shift working, the consumption of alcohol. There's a lot of events that occur outside of the workplace. So my advice is that you should do a sort of RAG, red, amber, green risk assessment, identify what the risks are, and then identify what, if any, steps can be put in place to prevent your employees from being sexually harassed in the workplace. And when I'm talking about the workplace, that also includes an extension of the workplace. So it will include an overseas conference, it will include a Christmas party, it will include, you know, an off-site team bonding type event. It also includes email, text messages, social media. So what I want to do now is just go back and talk about what does sexual harassment actually mean. Okay, there are three components that have to be triggered under legislation, under the Equality Act that's been amended. First of all, there's got to be unwanted conduct. Okay. Secondly, it's got to be of a sexual nature. And thirdly, it's got to have its purpose or effect of either violating B, the recipient's dignity, or creating an intimidating, hostile, degrading, accumulating, or offensive environment for B. I've quoted that legislation, the wording as it is picked up from the legislation, but in short, it effectively means the conduct's unwanted, it's of a sexual nature, and it's created an unpleasant environment for the recipient. So that's broadly what we're talking about in terms of sexual harassment. I also mentioned less favourable treatment for rejecting or submitting to unwanted conduct. Again, that's you're subject to sexual harassment, and then it has the unwanted conduct or purpose of violating your dignity, creating an intimidating, hostile, degrading or humiliating, offensive environment. And this is the key bit here that's in bold, you are treated less favourably because you submitted to or rejected the unwanted conduct. So, if you said no and then you're suddenly subjected to less favourable treatment, or you've put in a grievance, for example, you should not suffer a detriment because of that. I've talked about conduct of a sexual nature. It's not just physical, it's not just assault or rape at one extreme. It can be a variety of different things. It can occur on social media. It can be simple as spreading rumours or gossiping. It can be unwelcome touching, hugging, massaging or kissing. Now, I was asked when I did this webinar last week, does that mean that you can't hug anybody anymore in the workplace? That's not what I'm saying. What I'm saying is, if it's welcome and it's wanted, that's fine. But if it's unwanted, that's where we start to realm into the category of it becoming sexual harassment. And if you're not sure, don't do it, or ask the individual recipient if it's okay to give them a hug. Suggestive looks, staring or leering, displaying of sexual graphic pictures, posters and photographs, which I'd like to think is less so these days. But then also comments that you might find funny or jokes that you might find funny, other individuals may not. And it's always the recipient and how they have received it and how they felt that's the key here. It's not the intention behind it. Sexual gestures, propositions, advances, intrusive questions about a person's private or sex life, or a person discussing their own sex life. Somebody may not want to hear about this. Text messages, emails, I've already mentioned, are an extension of the workplace, and making promises in return for sexual favours. So the point I'm trying to make here is it's very broad and wide in how it can occur. So you just need to be mindful of that. It's not just the grave circumstances of assault or rape or people making sexual advances to another employee. So we've talked about risk assessments. Just put up here a few of the things that you might want to factor in terms of your risk assessment of where the risk could be heightened. I'm not proposing to go through all of them. The slides I think will be sent out afterwards, so you can have those as an aid memoir. But what I do want to talk about is third-party harassment, and I know that both Christine and Nick will pick up on this from a different angle. But the mandatory duty to take reasonable steps includes third-party harassment. So if your employees are coming into contact with suppliers, contractors, hotels, airlines, whoever it may be, and even customers, you as an employer have a duty to make sure that you have done what you can in terms of reasonable steps to prevent them from being harassed by third parties. So that may mean that when you're contracting, negotiating with them, and I won't delve into this too much, that you might want to build in something into your commercial contracts. Again, I won't delve into too much in terms of your customers, but you might want to incorporate something into your booking conditions that, as a company, you don't tolerate the harassment of your staff and so on and so forth. So that's all I'm going to say about third-party harassment. It does occur, and it will continue to occur until companies take proactive steps to ensure that the people that their employees are dealing with have also taken proactive steps so that it may get to a point where there are reciprocal indemnities and warranties needed. I just want to spend a few minutes before we finish on the key takeaways to tell you about the changes that will come in, we think, next year under the under the Employment Rights Bill. Now, that's the landmark piece of legislation that the Labour Party announced within 100 days of coming into power. It's got some quite radical and generational changes in there, including unfair dismissal day one rights. But that's not what we're here to talk about. The point that I want to focus on is that when that legislation comes in next year, we think autumn of 26, that duty to take reasonable steps will be changed. There will be one very small word called all that will be added, so it will be all reasonable steps. But the addition of that small word creates a very much bigger, higher duty, because as an employer, you have to then do everything in your power, not just what's reasonable, to prevent sexual harassment in the workplace. The other thing that legislation will do, the employment bill in 2026, is create a standalone duty in relation to third-party harassment. So at the moment, if an employee is harassed, they have to piggy bank that claim in addition to another claim against their current employer, but that will, moving forwards, create a standalone duty. So there's quite a lot of bit of work for employers to be thinking about, not only in terms of updating their policies, introducing policies, rolling out training to staff, doing risk assessments, and even going further, you could have, workplace champions or a safe place or person that individuals can raise these complaints raise these complaints to. Training managers on how to deal with them, because if the worst thing that you could do as an employer is say, yeah, we've taken all these steps to prevent sexual harassment, but then a complaint is raised and it's dealt with very poorly or very badly, because that will not instill confidence in your workforce to raise complaints in the future. But also it may lead to that current employee who's raised the issue to resign and claim constructive dismissal. So it's a collective duty on all businesses, irrelevant of size, to stamp out sexual harassment. And even if the law hadn't come into force, I think society as it is, from a moral perspective as well, there's no place for sexual harassment of any nature in today's society, and certainly in today's workplace. Again, just to reiterate that the workplace is not just the four walls that you work in on a day-to-day basis. It's online, it's during travel, and we've all got this collective responsibility now to speak up, to report it, and to support each other. So I appreciate that is a very quick whistle-stop tour. Happy to take questions now or at the end. I know Christine and Matt want to jump in as well and to elaborate beyond employees.
Yeah, thank you so much, Amy. I mean, there's so much in there. There's so much in there, and this is a topic you and I have discussed this a lot, Amy. It's just so important, and it is something that's talked about so much more now, which I think is great in a way. It's really about knowledge. It's about knowledge for employees, and it's about knowledge for employers. So vital. I was speaking to Sarah Prager, who a lot of you know from Decca Chambers, about this, and she said, I think there's a lot of people sleepwalking through this. They're not aware of these new requirements, and it's going to hit them. It's going to hit them hard. And like you say, it's important to have a policy. That policy shouldn't just sit on a shelf. It's important that staff know about it and receive training, and really, really important that managers know about it as well, so that they can deal with it. Because I read, I don't know if you saw on LinkedIn, there was an article, it was an employment tribunal matter, but because an issue had arisen, but the disciplinary process had been dealt with so badly, there was like an extra 50 grand payout or something for, dismissal, because it hadn't been handled properly. And especially in cases involving sexual harassment, sometimes it's with a more senior member of staff, a manager and a younger member of staff. That manager cannot be involved in the investigatory process. All these things. So that's what companies need to be aware of, right?
Yeah, I mean, they are very difficult to investigate by the very nature of what's been discussed. They're very sensitive, they can be very emotional. You've got to try and control the gossiping that's going on in the background, amongst the workforce. And that's why employers do need to train managers on how to deal with them, because there's no point taking steps to prevent it and then if it does occur, dealing with it badly. And unfortunately, the number of claims, we are seeing an increase in the number of claims, and I don't think that's because there's more sexual harassment occurring. It's just now that people feel more confident, more empowered to speak up, but not only speak up to stop it from happening to them, but also their colleagues as well, because society just doesn't tolerate it anymore.
Yeah, no, you're absolutely right. And we've, I said whenever we were promoting this webinar, yes, this is for travel businesses, but it's for all companies as well. We've had this training internally as managers. If you're sending out people to Christmas parties or events or anything like that, vital you have this training. And if you haven't had the training, Ami's been out and about. She might as well be doing a roadshow, going round and giving training to different companies. So if you do want that training, we can provide that to you. So do get in touch. We've had a few questions come in, actually, a number anonymously, and then I've just seen one in the Q&A, which I'll come to as well. Ralph, yes, Ralph, great question. I presume that the workplace also includes anywhere that holiday tour leaders are working abroad. So whether that is one person leading a trip on their own, or two or more people working together in a group. Also worth clarifying how that applies to subcontracted staff. This is a great question. Tour leaders working for DMCs contracted to run trips for tour operators, and what the principal tour operator's responsibility is. So two questions there. I think the first one is, it does apply when people are working abroad, people are working in resort, Amy.
Yeah, it does apply. The Equality Act extends to their workplace overseas because there's sufficient enough connection back to the UK. The employee is most likely going to be a UK resident, but even if they're not, the employer will be. They'll be paid in UK currency normally. The contracts will be subject to UK jurisdiction. So that's the easy bit. And the second bit of the question?
The second bit of the question is, and someone else has actually come in with something similar, clarifying what happens with subcontracted staff. So they're not your employees, but say you're a principal and you're using a DMC that provides tour guides or drivers or whatever it might be. So something happens maybe between those employees of that company. They're not actually your staff, but that's going to impact your own trip. So how does your duty extend to them?
There's two things there. First of all, if a third-party supplier member of staff sexually harasses a member of your staff, if you haven't taken reasonable steps, you're not going to have a leg to stand on in terms of defending that. And that's why when you are contracted with these third parties, you need to say, well, what step, can you confirm that you've taken reasonable steps? That's the first thing. And the second point is, if it's not sexual harassment of a member of your staff, but it impacts at all because it's between the third parties staff, that's going to have commercial implications. And Christine, I don't think I'm going to delve into that too much because I know that you're going to pick up on that point.
Yes. Yeah. But it's I think that's why another reason why we decided to do this webinar today, because the impact can be so far reaching. It's not just, between maybe two people this incident happens, it's going to have knock-on effects to others down the chain, which we will deal with both in the commercial and litigation aspects, Ralph. So bear with me. Just a couple of other questions that came in kind of on the same vibe there, I guess. We run a lot of events and use a consultancy firm to staff those events. A lot of them are young females. What are our obligations here? Bearing in mind, these individuals are not our employees. I know who this is from, actually, and I guess without giving too much away, they run a lot of social events, a lot of auctions, charity events, and, maybe there's young people coming in to sell tickets, things like that. What are the obligations there with regard to those subcontractors that are coming in?
Yeah, the subcontractors are not your employees. That's the first thing. Okay. But if they are coming from an agency or from a supplier or a third party, I would expect, if they're not already, that third party to be saying to you, as the company that they are providing the services to, please can you ensure that you've taken, or give us an undertaking or a warranty or even an indemnity, that your staff have been trained, that you have taken reasonable steps. And that's as much as that third party supplier can really do, because there's no way that we're going to be able to control every action of everybody, but it's asking the right questions and getting the responses that you need to make sure that both parties have given the relevant training, guidance to their respective parties, employees.
Yeah. And like you said at the beginning, it's a real big reputational thing as well. If you become known as, a company that has events where, people don't want to go to work for you, or, these things are happening and you're not taking actions, that's not, that's not going to look good for you. So
no, it's massive. And when I talk about reputational risk, this is beyond it being published in Travel Weekly or TTG, for example. The journalists, basically, they look at the list on a Friday of the cases that are listed the following week in Tribunal, and they home in on the ones which have got sexual harassment, discrimination, because they are the ones that make the headlines. And if you are particularly are a big named employer, then that's gonna get more views and more readers, isn't there?
Yeah, and it's hard to come back from that. It's hard to come back to that. And the use of social media these days, so people go on and share their feedback. It's can have a big impact. Sorry.
Social media, I mean, that's probably how we've ended up with some really good campaigns, such as hashtag Me Too and so on and so forth. So it does spread awareness.
Yeah. Another question here. We have a lot of reps in resort, but maybe not so many managerial roles in resort as well. How do we deal with instances when we are not there in person? I mean, I guess that's about having a good reporting system, like you said, having that like go-to trusted person dealing with these matters promptly, offering assistance, those kind of things.
Yeah. First of all of those staff should be trained before they are sent out to resort. I mean, I remember doing some training to a hall full of reps who were, let's say, I can't name the company, but the holidays were for, let's just say, younger individuals. And they were like, basically, you're just killing all the fun out of us going. And I'm not killing the fun. You can have fun, but as long as there's consent there, as long as it's wanted, and so on and so forth. So first thing is make sure that those staff feel empowered to speak up, that they've had the training, they know what resources are available. And I think if they're all overseas, there will be someone back at home in the UK that they can pick up the phone to, they can report it, they can get guidance, they can get support. It's a bit like us, isn't it, at Travel. If we're sending a whole bunch of employees off to a conference somewhere overseas, and they will be given a number or support contact of who to contact whilst they're away in the event of something like this happens or something else happens.
Yeah, no, that's absolutely right. And final then question that's come in before we move on. How do we address an issue where an employee complains about a comment that another employee has made? They have found it offensive, but I, having investigated the matter, don't agree. Because this is such a subjective thing, how do you deal with that? Because you said in your talk there, Amy, it's all about how the comment is received.
Yes.
But
yeah.
But then if it's investigated and it's, how do you deal with that? Okay. I guess, yeah.
It's really difficult. And I think it is the recipient and how they have felt, okay, when they've heard that comment. It's not the investigator's job to consider whether they are offended by it. And that's the blur or the line that must not be crossed over. The investigator's job is not to prove beyond all reasonable doubt, because we're not in a court or police environment, is on the balance of probabilities. Is it more likely or not that sexual harassment has occurred, not how it was received? And that's the difference. And that comes into training and educating on investigating these types of things.
And people can be forgiven. You shouldn't feel bad. The amount of, clients we speak to and they're, I feel like I dealt with this badly or this. If you don't know, you're only going to do your best, but this is the chance to educate
Yeah,
yourself and to get that knowledge and deal with these things properly. And that's what you're here for, Amy, really.
that's right. And I think if
Yeah.
employees don't know whether it constitutes sexual harassment or not, speak up to a manager. Don't sit there and suffer in silence. And also, just I want to quickly touch on the bystander point as well. That I'm hoping that when you roll out this training about taking reasonable steps, it's not just individuals who are the subject of sexual harassment that feel empowered to speak up. But if you are witnessing it, again, you should be speaking up and raising it. You don't have to be the subject of the harassment. Just one very quick example I want to give. A client in Christmas party, they were all given vouchers for free drinks. One chap came along quite early, had his drinks, also consumed everybody else's drinks by taking their vouchers, got absolutely sloshed. He then did make advances of a sexual nature towards a female colleague. This was witnessed by two senior individuals. And then the victim said that she didn't want to make a complaint because it would get messy, that the families knew each other and so on and so forth. And so the company said, well, do we need to do anything in this situation? She doesn't want to make a complaint. So my advice was, well, you are two senior individuals. If you are turning a blind eye to it, how can you then demonstrate that you're taking reasonable steps to prevent sexual harassment in the workplace? You still have to look at it.
Yeah. No, I completely agree with that. One final question has just come in from Rebecca, and then we do move on. If workplace harassment has occurred, Amy, do you have to dismiss or are warnings, etc., appropriate? Does zero tolerance equal automatic dismissal? That's a great question. Amy, what do you think?
I think in your policies and in any training you deliver, you've got a zero tolerance policy. I think it would have to depend on the severity and the facts of that particular situation. A one-off comment that, there's a bit of banter to and from may be very different to a grave situation of sexual assault. So I can't just give a very carte blanche answer of yes, no. It will depend on the facts and circumstances. So as a typical lawyer, I'm sitting on the fence there. But in most cases, if there is a finding that sexual harassment has occurred, it's more likely that it will end the employment of the individual.
Yeah, it's going to depend on what your internal, policies are, your staff handbook, your disciplinary procedure, Rebecca, all of those things. So if that is something you want to pick up on further, do contact Amy direct, because
and it's not just it's the way that you deal with the process as well, which is equally important, because if you mess that up, then that can lead to a whole other can of worms.
I agree. That's half the problem, not dealing, well, a big part of the problem, not dealing with it properly when it occurs. We could talk about this all day. And like I say, if you have queries and follow-ups, and maybe this has just made you think, oh gosh, we need to get our house in order. Like I say, so many people, you're in the same boat. Take action now, and move forward from it. Don't worry if you're not there yet. We can help you do that. So do get in touch. A couple of other issues, like I said at the beginning, the way we want to address things. Thank you, Amy, as well. Amy knows everything about everything. I love listening to Amy's stories. Yes, we wanted to address this matter also because it's not just your employee from that sort of perspective. Like I said earlier, when an instance occurs, it can have so many more repercussions further down the line. It can affect maybe, an instance between two employees might affect your customers in resort because their trip can't continue. A customer might be assaulted or harassed by a member of staff, or vice versa. So how do we mitigate that risk and deal with these things when they happen? So I'm going to pass over to Matt now again. Everyone knows I don't need to introduce anyone. Matt is going to talk about things from a commercial perspective. So what can you have in your written documents, your booking conditions, these sort of things to mitigate loss and protect yourself should these instances occur?
Amazing. Thanks, Christine. And good morning, everybody. Nice to see you all. Christine, a second ago, you mentioned the need to get ahead of issues like this. And in the world of commercial contracting, we got you covered on that score. And this is really good news because the kind of things that I'm going to quickly talk about now are usually already in place. How can we get ahead of this? What are the things that we can do? Okay, so I think there's breaks down into two basic ways of doing it. I'm talking here about typically a travel business of some kind, because I'm going to talk about booking conditions and the kind of things we put in there. But it has a wider appeal. It could be anything, you know, anything along that spectrum, certainly, and probably outside as well. So, all right, let's talk about that. Booking conditions, T's and C's. People might think this doesn't have any application to what we've been talking about today. Actually, it does, and most of you will have. And if you don't, then I would thoroughly recommend it. Have a clause in your customer T's and C's, booking conditions, whatever you want to call them, that is something like your behavior. And when we say that, we mean your behavior, dear customers, the things that we are asking you to do. So in there, again, you're asking them to behave reasonably. Doesn't need to be a huge, long clause, doesn't have to be massively detailed, but needs to nail down some fundamentals along the lines of, we want to create an environment here at this company, and we want you to have a good time, but we also want you to respect others as well. Because again, if you are trying to create this workplace for your staff and an environment for your customers to enjoy, this has got to be part of it. So again, let's not ignore the fact that it could be a customer that is potentially compromising a situation that one of your staff members, your reps, your managers, etc., might be in, whether that's abroad or whether it's in an event style situation here. So I think that's a relatively easy change. It doesn't need to be massively complicated wording. Of course, we can give you some pointers on that if you want. That's a solid thing to have in place. And again, I'll touch back to that in a second. Secondly, we know that we are going to have, as businesses, contracts, agreements with suppliers, partners, etc. And in those already, we will have commitments flowing both ways on things like, as the slide says, anti-bribery, anti-money laundering, anti-modern slavery, all that kind of things. And actually, that is the kind of list that, dependent upon the business that you work for, the kind of environment that you're in, that is starting to get in some contracts quite a long list. Might be individual clauses that say anti-bribery, bang, 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 anti-money laundering, bang, bang. Or it might be something that I think increasingly we're seeing a clause in something like a supplier contract or a B2B contract that says something like regulatory requirements, and then kind of starts to list these out. And again, you can go into quite a lot of detail there if you want. It's going to depend upon the situations, because again, we've got to get these things signed, we've got to get them worded correctly, and you will know what kind of environment you're in, and whether or not making things like supplier contracts longer and more complicated is a good thing. Is the other side going to expect that? Do they want that, or are they actually looking at the other way and saying it's already too long? Rightly or wrongly, that's a complaint which we've had for many years about, particularly for tour operators and whatnot, contracting, which is, these are too long. We don't think they are. We think they're spot on in terms of the kind of things that we put together here, the kind of things that we see that you all have. But we know that some partners abroad might not like that kind of length, and this is only going to potentially add that out a little bit. But this is where you would want some wording in that helps cover off all the things that we've got here, so that there is a commitment from your supply chain to help you comply with the kind of obligations that you've got. So it's an easy thing to say, it's a slightly more difficult thing to put in place, but you already have the architecture there to be able to do this. And for what it's worth, I would be very wary about working with a partner that doesn't want to do that. It feels like a bit of a no-brainer. Why would someone not want to submit to this kind of thing? But you do see it. Every once in a while we will see suppliers, particularly abroad, looking at a supplier contract, say for a tour operator, and they'll cross out everything to do with anti-bribery and anti-money laundering. Well, what do we make of that? Putting amazing commercial relationships aside, I know all your commercial relationships are amazing, but think about that. If you have a partner that is looking to cross out things like that, that's a question mark in its own right. So, as the slide says, there's no absolute right or wrong. This is going to depend on your business and how you do it. But I think just with those two steps, putting it in whatever is you're doing with your client, whether it's a tour operator, contracting with customers, whether it's a TMC, and you've got your corporate clients, etc., having something in there about their behavior and the way that it kind of moves in this direction. And then similarly with your suppliers, partners, call them what you want, making sure that you can get these things hooking in and starts to work. And as I say, who says no to that? And that's pretty much it from me, because I think with those 2 points, you cover a lot of ground. And as I said, you've already got a lot of things there that are in place.
Yeah, yeah. It's about covering yourself, like we said at the beginning, it's about covering yourself from all angles. So this is obviously, we started out with Amy and saying about the relationship with employees and your requirements there, but it's the repercussions that that can have. So for example, Matt, in most supplier contracts, you have an indemnity clause. Okay, that's pretty standard. It's what you would want in there. Specifically, that indemnity usually covers, you know, if loss occurs or something like that. We would want, and this relates back to the couple of questions that we've been asked today, you know, we're working with a supplier. What if something happens between their staff that means our trip can't continue? You'd want something in there that covers you, that says if the trip can't continue because of, you know, an issue internally with staff, you cover us for all losses. Because what if we have to send customers home? What if they can't continue? Something like that. You'd want specific wording in there from that angle.
You would. And what we are all about, what we've always been about, is giving options, giving you a position to work from that might cover that kind of situation. So as you say, Christy, this aligns rather nicely in the sense that if you put some wording in here, as we've discussed, and you've already got wording in your supplier agreement that says, you know, if you breach the contract, then kind of not complying with, you know, reasonable requirements on this side of things turns out to be a breach. It all just kind of links in nicely and these things lock in. So and it gives you the option. You hope it never happens, but you know what we know. All the people that are attending today do is quite a complex thing. A lot of moving parts, and it's very people heavy. So the chances that this is going to happen. So you know, why not cover yourself early? Get this stuff in, and then you give yourself that option next time.
Can I just interject? And I think because damages for sexual harassment of your employees is potentially unlimited, and they can be very expensive, not in terms of just the damages that are awarded, but also in terms of legal costs of defending them. Okay. I'm talking tens of thousands of pounds, if not hundreds of thousands sometimes. I think, you know, it would be very sensible not only to have some sort of undertaking or warranty that they have the third parties rolled out or taken reasonable steps, but also once they've given that undertaking, that if there is third-party harassment, sexual harassment by a member of their staff towards your employees, that they will indemnify you, because you know, we're talking quite substantial money here, and I think those sorts of warranties and indemnities are going to be reciprocal, not just, you know, the third party wanting it from the company that they're supplying services, but vice versa as well.
Yeah, yeah, very important. And I think also, you know, we've concentrated on this slide, Matt, about B2B agreements with your suppliers, that kind of thing. It's also about your customer facing T's and C's as well. Again, from a reputational point, as well from a protection point. We've had people, you know, contact us and say, we've got a tour out, you know, at the minute, there's 20 people on the tour. One customer said something to another customer, that customer is taken offense by that, and now they want the other person removed. It's really important to have, you know, whether it's a behavior term or something in your customer facing T's and C's, so that you can say, we are removing you from the trip for XYZ reason as per our T's and C's. You know, you see this on airlines all the time, Ryanair, Ryford, they don't accept inappropriate conduct, that kind of thing. That's important to have in your consumer T's and C's as well.
100%. As I mentioned earlier on, you definitely want that, and the good news is most operators will have a behaviour clause or something similarly named that can cover that off. Might be fine as it is. Definitely worth, you know, we talked today about having practical tips. Have a look, see what it says, see if you feel it covers this, given the nature of the business that you are. And if you need to tweak it, then you need to tweak it. But as you said, it gives you the option to then kind of found something like that later on.
Yeah.
And this starts to get into kind of, you know, your side of things now. So I won't go into it too deep, but, you know, we've kind of worked hard here to make sure that the setup that we've got for tour operator clients is giving them the maximum amount of protection as possible in light of cases like X against Kuoni. So I won't go into the details, but it's like trying to make sure, because again, that situation was a bit of a weird one. I don't have time to get into it today, but, you know, was not a supplier of the hotel. That was the kind of big question, wasn't it? It was one of the kind of staff members, but it was that staff member working in a way meant that they were responsible, etc., etc. And, you know, you have this potential situation where a tour operator is responsible to a customer but the supplier is not responsible to the toll operator because of the way these kind of things work out. And we're trying to bridge that gap as much as possible. So again, it starts with the T's and C's. It continues on through any number of other things, and hopefully we get there and give it proper coverage in the end.
Yeah. I mean, Kuoni, everyone's probably, heard of it. If you haven't, you'll find so much about it online. But this was where it came out that if someone is in your sphere of control, that was kind of the key phrase that was taken away. So a tour operator was found liable, even though it was an employee of the hotel that carried out an assault. They were within the sphere of control, and therefore liability attached. So when that case happened, which was a number of years ago now, everyone updated their T's and C's, everyone updated their supplier agreements to protect them in that sense. Now is the time to review your documents anyway, guys. You should be doing it every year, every couple of years. Get your T's and C's in order, your supplier agreements, just get them checked over. It's not a case of rewriting them all. But as legislation changes, as new things come to light, it's important that you make sure they're covered. So do get in touch with us if you just want a quick refresher on that. So thank you so much, Matt. I just want to say a couple of bits at the end here. I don't know who's in control of the slides by now, but if we pop on to the next one, things from a litigation perspective. So like I say, at the beginning of today's session, I've worked in litigation and in personal injury now over 10 years. And you'd always get the odd sexual assault claim, sexual harassment claim, a few a year. And it used to be more so maybe in a spa in a resort, maybe a masseuse in resort, maybe in your 18 to 30s holiday groups, these kind of one-off things. I cannot tell you how many cases and instances I've had in the past 6-12 months about cases ranging from serious sexual assault all the way to, comments of sexual harassment, things like that. Customers ringing up, one customer said this to another customer, how do I deal with it? These things are just increasing. Like we say, there's numerous reasons for that. I think we're seeing a lot more solo travelers. I think we're seeing a lot more female solo travelers. I think people are traveling to more remote destinations by themselves on adventure trips. We're seeing a lot more instances where individual solo travelers are doing longer trips, maybe with the same people that are working for the tour operator company or whatever, rapports are built, but then things happen, all these kind of things that are leading to more increased reports of this kind. And also, like Ami said earlier, just people are more aware of it. They're not as afraid to report it. And that's why we're seeing an increase. From a litigation perspective, so when a complaint is made, maybe a complaint is made, that's when it's going to come to myself. Everything we've said today already is about minimizing risk. That is always what it comes down to in cases of travel and things like this. You can never completely eliminate risk unless you don't start the holiday in the first place. There's always going to be some element, but our job is to try and minimize that as much as possible. Know your own business model and look at where those risks lie. Okay, so if you are dealing with solo travelers, that in itself is a risk. If it's an balanced male-female ratio, if they're boozy holidays, if you're doing wine tours, all these kind of things take into consideration. Background checks on staff when you're employing them, training given, like Ami said, training, knowledge, education is just so important, and also your reporting procedures as well. Timing of your trips, location of your trips, who's involved, all these things to minimize the risk in the first place, okay? Because the more we minimize it, the less chance it's going to happen. And just on to the next slide then, if something does happen, okay? So of course, we don't want that to happen, but in some instances it does. The first thing you need to do is establish the facts as a matter of urgency. There's two sides to every story. It can be quite a difficult thing. I find these cases difficult. I'm not a criminal lawyer. If I get a case in relating to a rape or a serious sexual assault, I have to sit back, talk my clients through that. Okay, these things are very sensitive to deal with, but seek to establish those facts as a matter of urgency and speak with those involved. If there's any witnesses, if there's any third parties, and get the facts straight as soon as possible. Keep a proper and detailed record of those. And then obviously get in touch with a professional if it's not ourselves, whoever your legal advisor is, as soon as possible so that we can deal with these and again mitigate the impact it might have. You have to think of these things from a financial point of view, you know, damages that might be awarded, your PR, okay, so your reputational point as well. How do we deal with that in the circumstances? Can we fight it one way or the other? Are we prepared to take it to court? All these sort of instances. And then, of course, what can you learn from things as well? There is nothing worse than when someone comes to me and says, this incident has happened. It's funny, actually, we had a bit of a red flag with this person before and nothing happened, you know, this kind of thing. And I hate when people say that because it's almost like we've missed an opportunity. So learn from these things. And if you're in any doubt whatsoever, do get in touch with us and we will do our best to assist, as always, help you as we can. We've got a question in from, we've got a couple in from Debbie. I've just seen if Matt and Amy want to come back online here. Let's see.
I think the first question,
sorry.
Go on. You go. I think you've already answered it, Christine. Can you briefly state what the essential steps are for a resort to take if a customer states they were sexually harassed by a member of staff who was employed by a third party? I think you've covered that in one of your slides already.
Okay, right, no problem at all. Debbie, let us know if we haven't, but if we've covered that one. And what can we do if a young, recently employed staff member was sexually harassed by a customer? Well, Amy, do you want to deal with that from obviously they're your employee, and then I can address it from a litigation?
Yeah, I think the fact that they're recently employed is neither here nor there, because the prevention and duty to prevent sexual harassment occurs irrelevant. The employee in question could potentially bring a claim if they say wanted to. As an employer, you'd have to demonstrate that you've taken reasonable steps for that individual not to be sexually harassed by a third party, in this case the customer. And that's why, you know, things you won't be able to control all the actions of customers, but simply by incorporating it into your booking conditions and making sure that wording is there would help you to sort of defend that. But I assume in this situation that the employee hasn't raised a grievance. So what can you be doing as an employer? I think it's more around the pastoral side here, offering support, offering counselling if they need time off, making sure you do take steps moving forwards to ensure that that sort of behaviour doesn't occur. So I think it's more work around the pastoral side to make sure that employee feels supported.
Horrible situation, Debbie. If that is something that's going on, you want to talk about it, give us a shout. It's never nice to deal with. I would say when dealing with the customer, obviously, like I said, you're going to carry out your own investigation to see, you know, what you believe has happened here. Mitigate that risk, remove that risk. Okay, if it's the same in any, you know, instance. If you have customers in a hotel where there's an outbreak of food poisoning, you get the customers out of that hotel. If there is a customer there that you believe has sexually harassed a member of your staff, you remove that customer, and your T's and C's with your customer, like I say, will have a behaviour policy in there. So long as you have your own record, your own report of what has happened and your reasonable reasons for removing that customer, then you've got yourself covered in that respect. But that's a horrible instance if it has happened. And if you need any support with that, do let us know, even to chat through. That brings us up to 11 o'clock, which is a full hour, and I can't see any more questions coming in. What I think we really need to take away from today is it's every day is a learning day, and it's just about education and knowledge. And now that you're aware of these things and you've joined us today, let's do something about it, okay? So get your T's and C's looked over, get some training for your staff, get some training for yourself. I think on our final slide, when we close off, we do so much training for members. I really do think the more knowledge you and your team have, you know, the more successful you guys are going to be. So if there's anything you'd like training on, and of course in relation to this topic as well, get in touch with us. Get all your booking documents up to date, and heaven forbid if something does happen, get in touch with us and we will be here to support you through it. This will be available online. It's recorded. We will share it. We will share the slides. And of course, if you have any follow-up questions, just drop us an email or a LinkedIn. So it's lovely to see you all. Thank you so much for joining. I hope you found it helpful, and we'll see you all very soon. So thank you so much, everyone. Thanks. Bye.